Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we are here today with my good friend, Phillip Miller, who is a trial lawyer and a trial consultant to the stars. And Phillip, I know, is in a really good mood today, which is great because he just got out of trial with another friend of ours by the name of Sach Oliver down in some small town in Arkansas. So, Phillip, first tell us about, just give us a little snapshot of that case. And we're going to talk about it a little bit later.
It was a wrongful death case involving a Kroger truck that hit a pedestrian who was pulled over on the shoulder of a road and then denied any responsibility and tried to blame everybody they could for the death of that young man.
And this was against the Kroger Corporation?
It was. They're a large company, and so they have, I think, over 900 drivers nationwide.
Now, you were consulted on this case, and so I want to, before we get into your consulting practice that you do today, first, I want to tell us, how did you get into the law? How did you find your way to this profession?
I didn't have any plans to be a lawyer at any point in my life, really. I started law school because my father, I was just in graduate school at the time getting a master's degree at Penn State. My father died, and I came home, and my mother died within 11 months of that. But in between those two things, I decided I was having to deal with lawyers because of my father's estate. So I decided I would go to law school. I thought it'd be good information. And I had nothing else to do with my time. I was moving to a new town. I'd never lived there before, which was Nashville. I never lived in Nashville. So I didn't have friends there, family there. I didn't go to high school there, college there, anything. And so I said, well, I'll go to law school. I went to law school at night. And I thought it would be a good way to sort of learn something new and sort of fill my time.
You know, my journey to law school wasn't much different, even though my dad and my brothers and sisters were all lawyers. Because I had no burning passion to become a lawyer. I just didn't want to be uneducated and, wanted to have a default because I was a house painter at the time and doing pretty good. And, but it was more of an intellectual process than it was I've been wronged. I'm going to do something about it. So Phillip, you get to law school, but before you get to law school, you went a little bit later. So what kind of work were you doing before that?
I went to law, as soon as I got out of my graduate program, got a master's degree, the first job I had was working on a federal grant for the Tennessee Department of Mental Health and Mental Retardation. And my job was as a systems analyst because my master's degree had been in public administration, but my specialty was in system analysis, especially when it came to automated record systems. And so the whole thing was that's what I got into. And I ended up working on a project where we developed a performance-based record system to use in institutions for mentally retarded and developmentally disabled people, where you could measure their progress. And you could see who was making progress, who wasn't making progress, and make management decisions based on what residents actually needed, what their problems actually were.
How do you think all those, and how many years did you spend doing that?
Ultimately, a total of 5, but my jobs changed over time. So my last job, I was the executive director for developmental disabilities for the state of Tennessee, which is a nice job. I really had kind of gone as far as I was going to go in that organization when I reached that job.
And how do you think, and you spent a lot of time with the folks that you were, I assume, that were in your care, that you were in charge of, these people that had special needs. Is that right?
Yeah. So I was inside every large institution that provided care to that population in the state of Tennessee, as well as the community-based organizations that were doing the same thing. So I got to know a lot about sort of the problems that people who have developmental disabilities of one kind or another have, and the kinds of problems that are associated with really providing care for them, either in an institution or in a community kind of setting. And so part of my job then was helping fund those organizations later on in my career.
And would some of those type of problems be like the folks that memory problems or troubles following directions and doing basic things that we were instructed to do?
Yeah, and physical problems. A lot of them had physical impairments as well. So you had people who were profoundly involved in terms of diminished cognitive ability. For example, they might not have language. They might not have a lot of receptive language. They might not understand a lot of words. They might have difficulty dressing themselves. And so sometimes the training that was being provided was teaching them to be increasingly independent so they could dress themselves. They could toilet themselves. They could brush their own teeth, that kind of thing.
How do you think that experience has helped you today in your career when you're helping trial lawyers? Because I work with a lot of trial lawyers, and some of them they don't listen. They don't have trouble these challenges, and and jurors and stuff. And so having all this work with how do you think this has really helped you? Do you be the consultant with the juries?
Well, I mean, it's all about learning theory, really. I mean, most of the people I end up working with, including my first wife, had a master's degree in behavior modification. So those are the people that were directly hands-on training people and teaching people how you can train someone to dress themselves when they're really at a relatively low functioning level. How you can get them to do things that people wouldn't expect they'd be able to do just by way of using basic learning theory and learning models. And so when it comes to talking to jurors, I mean, jurors don't have those kinds of cognitive or other deficits, but the principles of learning are exactly the same. And so being able to put yourself in those shoes and figure out what does this person need to hear to learn what's important in this case ends up being a critical skill if you're a trial lawyer.
So you practice a law. You go to law school. You're going at night. So I went at night too because I worked during the day. So that's just a different experience. But I really enjoyed it more because I'm like 4 years at night, kind of coasting along, working a little bit versus 3 days, 3 years of like super focus. I'm like, I think I'm going to go with the slower pace. But you get out of law school, and so tell us about your career prior to this, your consulting career, the track you
So
got.
I had never clerked for anybody. Had never spent a day in a courtroom. I didn't really know any lawyers other than my law students in my classes and my instructors at school. And so I decided I wanted to try practicing law because I thought I'd kind of reached a dead end career-wise. And I talked to a couple of older lawyers that had good reputations and say, can you recommend me to talk to someone who might have some space that I could rent at least, and I could sort of, get started with the practice. Maybe they'd have enough business they could refer me some business. And I got a really great referral from a really well-established, great lawyer here in town named Cecil Brandstetter. He'd been a civil rights lawyer, union lawyer, just wonderful man. And he recommended me to a group of lawyers that I went and joined with, and they had an empty office, and I started paying $500 a month just to be in this office, and no secretarial, and had to figure things out. And then if they had anything extra they could throw my way, they'd do that.
So you start out there as, rent the space, and where does your legal career evolve from, when you first start out, you got no idea of the courtroom or anything like that? Because eventually you do find your way to the courtrooms.
Yeah. So I started off like anybody in that situation. It was like whatever came in the door or anything that these guys might refer to me, I would try to do. So I did, divorces and small-time criminal stuff, and I might do a contract dispute, small claims court. I really just bankruptcies. I mean, basically did just all kinds of stuff, and some of that I would do more than another. And probably within the first 3 years, I had a personal injury case that I had to try to a verdict, and it wasn't. The lawyer referred to me, didn't think it was a particularly good personal injury case, but I sort of made the most of it and tried it to a verdict, got punitive damages, and settled it for the policy limits, and the client
How
was
much
happy.
was that? How much was that? Come on, Philip, we got to know the numbers.
I think it was $25,000 probably, which is about the policy limits. Of course, they made no offer on the case beforehand, so it was a big win. And I'd never, you remember I don't think I made more than $1,000 a month the first year I was practicing law. And so, all of a sudden I had a fee on $25,000. It's like, whoa, this is a lot of money. So after that, I started doing more personal injury work because I like being in the courtroom. I like trying cases. I thought I was able to connect with jurors and have conversations with them about the case that made sense to me. And I like the workup too. So, I thought this is something I can do, I can be good at, and I can make a decent living. So I started doing exclusively personal injury work as much as I could pretty early on after that.
And so tell us how your practice, though, really transitioned from, well, first, how many cases did you try? You think you tried?
52 to a verdict?
Oh, just ran rough. I was not that you're counting, but roughly 52.
No, I had to count it because
Phillip, that was a joke. That was a joke, Phillip. No need to answer to my jokes. If you said 52, you said about 50, that wouldn't be so specific. And so you got 52 trials behind you, but now your life has transitioned, I think, to, consulting. And so tell us about, what qualifies you, the training that you've done that you believe qualifies you to help everybody or anybody on, their cases, their trials.
Well, there's a lot because I've had my approach towards being a lawyer is I got to have more training and learn more than they taught me in law school. And so I don't think a year has gone by since I started practicing where I didn't have 50 or more years of CLE every year. And I took all the CLE that was available because I wanted to be, I figured if I was, the better I was, the more successful I would be. And so I did lots and lots of training. And that involved everything from my first course in trial advocacy, I did at NEDA. I did a 10-day program at NEDA. Then I did a 3-day program at NEDA in negotiation. I did a 3-day program with Harry Philo, who is an expert at products liability from the state of Michigan, by the way, and went to Harvard and spent 3 days with him, learning all about products cases. And then I did what else? I did a bunch of stuff. I ended up I did the ultimate advocacy course at AAJ offered, which had a combination where they would have teams of lawyers and consultants that would be over each group. And so you would have sort of lectures, and then you'd go into a small group and work on a particular skill and get feedback from both the trial lawyer and from a working trial consultant as to what you're doing and how you could improve it. I did all of that. I sort of exhausted all the programs that I could do. And I wanted to see whether I could get on faculty for something, because I figured if I got on faculty, I'd be able to continue to learn and I wouldn't have to pay the tuition. And so I was lucky enough to be able to do that. I did a good job. And I also learned if you want to be on faculty for those kinds of programs, you probably have to be able to do more than just talk. You have to be able to, have you written a paper? Do you have a presentation you can do? And so early on, I started writing stuff. And by writing stuff, I learned more about the subject matter, and I was able to talk about it, present about it, and teach people about it in a way that if I was just kind of showing up, never would have happened. So I got to be a skilled instructor as well as a continual student of trial skills, because that's the only way that I would be able to continue to teach. Because everybody wants to teach because they think it's a marketing thing. They're going to get business from it. And for me, it was I just wanted to have the information.
And you talked about doing writings. I know you've written 2 books for trial guides, and both those 2 books are really relevant to what you're teaching at Trial Lawyers University coming up in just 2 weeks now. By the time this podcast comes out, it'll probably just be a week away. And so tell us about, the first book you wrote, I don't know, but one of the books you wrote was on depositions with a friend of yours that's passed away now. So tell us about the depositions book first.
So my friend Paul Scopter and I had been teaching at AAJ's Advanced Deposition College for probably 5 years at that point. And they asked us if we could write a book that could then be used as the text for that program, so that all of the instructors, and whenever that program was done, there was a consistency in content. So that we're teaching specific skills, and we're teaching the same kinds of skills, so that when people came to the program, no matter who was there teaching it, they were going to be getting the same kind of information and the opportunity to acquire those same skills. And so that was the beginning of writing Advanced Deposition Strategy and Practice. And the title is because depositions are so much a part of trial strategy that if you're not thinking about strategy when you're taking the deposition, you're just sort of missing the boat completely. And so the whole emphasis, not just on here's the kinds of questions to ask, but what is the strategy behind the content of your depositions? Where are you going with this witness, and how are you going to be communicating and teaching the jury what they need to learn and believe is true in order for you to win?
At Trial Lawyers University on Thursday, October 17th, you and your buddy Ed Ciramboli from Pennsylvania are teaching a 1-day depositions master's class for, I think, 10 students. So what kinds of skills and knowledge where people gain that come to this, little, because, you've been, and you and Ed and a bunch of other folks that are coming, like Sach, continue to teach every year at the, AAJ Advanced Depositions College. So tell us, folks, what they'll learn if they come to the workshop with you and Eddie at TLU.
Right. So at the Advanced Deposition College, we'll take 3 days, so we have a lot more time. But when Eddie and I are in a small group, we can kind of deliver a lot of that content all at once. And while we will try to make it specific for the people in the group, in terms of the problems they have, the things they want to talk about, there are sort of fundamental things we're always going to talk about. So we're going to talk about, for example, how do we establish rules in a case through the mouth of a defense witness, right? And then what are those rules? And so part of it is not just how to do it, but what are the important rules or concepts you want to introduce in your case that will make a difference? They're going to be case critical and dispositive of outcome. What are those things? And then how can we get those out of the mouth of the defense witness or the defense corporate representative? And so that's one of the things we teach. That's usually really a big deal to teach that. So there's multiple steps. So for example, we'll talk about rhetorical questions. What is a rhetorical question? How can you use a rhetorical question to put a witness in a position where they either give you what they want or they lose any credibility with the jury? So that's an example. We'll talk about rhetorical questions. We'll talk about clean language, which clean language is a really sort of an advanced technique, but it's a way of getting information from a witness that they never would ordinarily have given you. And it was a technique originally developed by a counselor who was dealing with adolescents who were behavior problems, if you will. And the last thing they want to do is tell some adult what they really think or feel about a problem. And clean language is a way to get information that people wouldn't ordinarily give you. And it's a great technique. So that's one of the things we teach. And then we'll teach about, of course, the importance of having visuals as components of any deposition, especially when it deals with the critical points you want jurors to remember.
How about the Miller mousetrap? We'll be covering the Miller mousetrap. Put you on the map.
That's true. Well, we'll talk about the Miller mousetrap because the Miller mousetrap is part of that. How do we get people to give us a rule or a principle that is compelling, and yet we're going to be able to use it against them in the actual trial? And so we'll talk about the mousetrap and how to use it. And to the important thing for us is people understand is like, how do you eat an elephant? Like one fork at a time. You just don't go for the kill shot. Let's build it. And when you get to the end, you're going to have everything you want. But part of that is teaching the build.
My buddy Muhammad Ahmad took your class and used your techniques on some of his expert depositions. And I remember him, showing me it was a while ago, but showed me the video, how he had like a true or false or something like that, having the witness do it. And then he went on to use those depositions and got himself, him and they got a $51 million verdict on a case that with a $5 million offer, and the highest verdict in that county was $12 million before that. So they put it to good practice. It's great when you see the stuff you teach somebody, when you see them go and apply the skills and like get a result. Even though they're not sending you, a check, it still feels so great to help somebody and know that you helped them, be a winner and achieve some justice and feel good and do the right thing. The second book you wrote is on focus groups. Tell us, a little bit behind that book.
So, what by the time we had finished our book on advanced deposition strategy and practice, one of the things that both Paul and I knew and were doing and were talking about was focus groups and the importance of focus groups. The problem is that there were some lawyers that were doing focus groups. Some lawyers were doing focus groups really well. Some had no clue what to do, and were doing it anyway. And so the question is, what can we put together as sort of almost a do-it-yourself version? What are focus groups? How can you do them? What are the things you can do to make sure that the information you get is more reliable, more focused, and is something you can then translate into a trial presentation that makes a difference?
These focus groups and the book that you wrote on focus groups, are focus groups some of the stuff that you help people with when you do consulting with them?
When you work as a trial consultant, inevitably, one of the things that lawyers know about trial consultants is they do focus groups. So you inevitably get asked about doing focus groups. And I always recommend it as well, because just because you think you know the case, and you do know the case, doesn't mean you really are getting what the juror's perspective on that same set of facts might be. And the only way you can learn what jurors are thinking about or asking about or don't understand is to ask people who could be jurors. And that means doing a focus group. Now, you can also do it by way of polling or surveys. That's a good way to do it as well. But we can't stay inside our heads and really understand what a case is about. We can't, asking your partner is great, but that doesn't necessarily tell you what a juror is going to think or feel about the evidence that you're presenting in the case. So we have to talk to real people about that and learn from them.
Besides the deposition class, you're teaching another workshop on opening statements on Saturday morning. Give us some background on, what people will gain if they come to that, because they're obviously skipping 9 different lectures. They're skipping. If they come see you for that, they're skipping Nick Riley and Sean Claggett and David Ball, and Brian Panish and Joe Freed. So what is the benefit they're going to get by coming to working with you just in a very small group?
Well, the difference is that we're going to have a very concrete work product, hopefully, for each one of them in terms of an outline of here's what you need to roll into your opening. And sometimes that ends up being is this the right opening for the case? Because the first instincts that someone might have about what they need to talk about may not be the best place to start in terms of an opening statement in the case. So I just worked with some clients earlier this morning, and we talked about opening, and the first instinct as to where they were going to go at opening, I said, well, let's talk about that, because maybe that's not the best place to start. So when you think about structuring an opening statement, anybody can do an opening statement, but is it about the right theory? Is it really about the kind of thing jurors are interested in hearing about, or are you just reciting facts? So the recitation of facts is something we talk about in terms of, is there a trial story? Where is it? Who's it about? And so we have to figure out all those issues as a part of getting to the opening statement.
I want to back up a minute and talk a little bit more about your background, because I know out of all the people probably walking the face of this earth, that you've probably spent more time with Rodney Jew, very well respected and trial consultant out of Northern California, Napa Valley. Tell us about that time with him and what you learned by studying and working with him.
Well, I met Rodney as a result of being on faculty for some AHA programs where he was invited as faculty as well. And initially, I loved Rodney. He was super smart, and he'd say a lot of stuff that, I got, but sometimes he would use words like, for example, filling defect. And the people in the audience wouldn't have any idea what he was talking about. But anyway, I developed this conversation relationship with him where I understood where he was doing. I liked what he was doing and what his approach was. It was very intellectual. It was very structured towards identifying the things that will cause you to lose the case and focusing on those first and finding a way to make those irrelevant or immaterial. And then it was always about develop visual support for your points. So it's not you just talking, but there's some visual anchor that the jurors will have so they remember what the key points are of your presentation and in your case. And so I actually was on vacation in California. I went by his office in Palo Alto, which is where he was at the time. He invited me to come in and sit in on a work session with him, which I did. And it was an interesting case, got it. And then maybe within a year or so, he had to have some throat surgery. And he said, would you mind coming out and running this work session for me? I don't want to cancel on him. And I'll be there, but I just can't talk. So I went there, and for 3 days, I sort of ran a work session with Rodney in the room. And it was very successful, and he paid me a little money. And I was happy with that experience because I got to do what he was doing, and he was there the whole time. But then after that, he got a large commercial case that he really could afford to and wanted to bring me in full time. So I leased an apartment in Palo Alto, and I worked with him about 2 weeks a month for about 2 years, a little more than 2 years, leased a car. And every other week I would go to Palo Alto, spend a week working on some case when there's the reason that he wanted me there, needed me there, there'd be 5 lawyers in there. And if it's just you and 5 lawyers, they just exhaust you. So you need to have sort of a tag team approach when you have that many lawyers and you're working intensively on a case. Because if you lose your focus and concentration, it's not going to be a productive day. And people are paying too much money to have an unproductive day. So that came in, and I enjoyed it. But at 2.5 years was up, and I was going back every other week and practicing law, which turned out to be okay by and large. And that time came to an end, and I closed up the apartment in Palo Alto and said goodbye to Rodney. And quite frankly, Rodney, I can tell you everything I know about Rodney. Love him. He's a super smart guy. He has a methodology that he uses now. It's a little different than what he was using when I was working with him, but he has a method of looking at cases that allows people to have some structure in their strategy and in their case analysis. That it's very, very helpful. And so I learned his initial methodology. I think he's evolved from that. But the point is that what you're really buying with Rodney, what you're really buying with me as a practical matter, is his brain. Because, he's just a super smart guy. He's got lots of experience in all kinds of different cases and all kinds of issues that come up in different cases. And so when you go to Rodney or you come to me, it's the same thing. I have a methodology that I use. I know how to ask lots of dumb questions that will make your case better, but you really end up buying someone's brain and experience. That's what you end up buying. And if that brain and experience is what you need, then it's worth whatever it costs. And so with Rodney, we know exactly what it costs. He's an expensive guy, but I always think if people go to Rodney and get what they pay for.
That's the goal. Well, the goal is always to, I think, from a provider, always to give people a little bit more than they pay for, so they always feel like they're ahead on the exchange. You, besides all this training with Rodney Jew, you've done quite a bit of other training to really enhance your skills as a consultant to help people. Give us some insights on some of the training beyond Rodney Jew you've done.
So I've been trained. I've had, 6 days of training in reading microexpressions. And the training, I went through a company that was based out of San Francisco who treat all the alphabet soup security agencies in Washington, D.C. on reading microexpressions. Microexpressions take place in a quarter second or less. This is it's a very well-researched area of study. And there are certain expressions that people make that they're completely unconscious of making it. But so when someone gives you a microexpression of disgust, it'll go by like this in the quarter second, and you think it's just a twitch. And in fact, it's the unconscious response to whatever they're hearing or seeing. And if you can read those microexpressions, you are in fact reading their mind. And so that's why the alphabet soup security agencies in DC want to learn that, because when they're interviewing any kind of individual as a witness or a suspect in a case of any kind, they're going to have one person asking the questions and one person reading the microexpressions of that particular witness to see if they're being truthful and what they're really thinking, what the real thought is behind the words, whatever they're saying. The fact that they're saying something doesn't mean that's what they're really thinking. So that's a tremendous skill to have. So I did the training on that. I know a lot about it. I can tell you it's very difficult to do because you can't ask. You can watch and you can ask, but you can't do both. That's what I can't do both. There may be some people that do, but it's a very interesting skill. And whenever you see someone make some facial twitch in their face, that's a microexpression. If you could slow it down to freeze frame, you could probably see what it is and have an idea about what's really going on in their head. So I did that, for example, and I liked it. Got a lot of experience. It's not really useful for me because it's too hard to do. But I did learn about it, I did the TLC. I did a TLC course in psychodrama because I'd heard a bunch about TLC. Of course, Dan knows a lot about TLC, but I didn't want to go to the ranch for a month, blah blah blah. But
really,
yeah,
you didn't want to do the dishes and clean the toilets and cry a lot.
I opted out of that.
Make a lot of new friends. If you went for a weekend, you probably did some crying. It's okay though. So your TLC experience in psychodrama, how was that for you?
Well, it was interesting, and I could see how you could use it. I mean, you clearly could use it, to me, it seems, in terms of building a relationship with a client and understanding things about their experience that you would never get otherwise. And so I thought it had great value for that. And I saw that in large part it was being used in lieu of doing focus groups. So people would put an event in action and sort of process through what was actually going on then. And then very often the information you get was very similar to what you get from a focus group if you're doing a focus group. So it was another way of getting different kinds of information and getting past, the limited view that you might have of the case because of your own confirmation bias. So I liked it, and I have not attempted to use it in a significant way because it takes more than a weekend course, I think, to really be good at it. But I have seen people who are really good at it, who are certified psychodramatists, and I think they can do a world of good on the right case. And I know people that have used Kayla Larimer, for example, is an example of somebody I know who's been used repeatedly by some of my friends, and they've had great results from it. So I have tremendous respect for it, but for the average practitioner, it's like, okay, you need to know what you know and know what you don't know. So I have some insights to it I think are valuable, but I don't try to practice that myself.
I think some of the challenges people have is they really treat psychodrama as the beginning and end of everything that's a trial is about. And, they ignore structure. They ignore, the stuff that's critical. And I think that's dangerous. And, people get punched in the face when that happens. And then, they don't know why it didn't work. And so it's like everything, you have to, whatever you're learning, you have to take it and be conscientious when trying to apply it in, the real pressure situations. So beyond psychodrama and beyond the TLC, any other stuff that you've...
Yeah, I was aware of a guy named Gerald Zaltman. Gerald Zaltman is a PhD on faculty at Harvard Business School who's written 3 books about metaphors and the use of metaphors in marketing. And he has a PR company and advertising company in Pittsburgh called Olson Zaltman Marketing. And I went there to get trained on metaphor interviews. So the way they would come up with an advertising program for a company, and they represent just a host of Fortune 50 corporations and do marketing and advertising for them, is they would talk to consumers one-on-one and discover the metaphors that consumers would use to describe and talk about a product. And then they would base their product advertising based on what is important to those particular jurors, what's going through their heads when they think of that particular product and the value it adds or doesn't add to their experience, what gives it value to them. And so metaphor interviews, I said, well, that's a great way to figure out what people are thinking. So we can do focus groups, but one metaphor interview of an hour is equivalent in terms of information to probably doing a 6 to 8 person focus group for several hours. So I said, well, if this is a shortcut to getting good information about what jurors think about a case, then I should learn how to do this. So Paul and I both went to the training program, got certified as metaphor interviewers, deep metaphor interviews, they call it, and then learned how to use that and still use that in terms of we're looking for metaphors in cases that will allow jurors to immediately understand what the case is about without us giving them 100 facts.
Eventually, when you decided to get past the theoretical, you decided to get into the physical parts of this thing called being a trial lawyer, you came to the TLU Skills Boot Camp a couple years ago.
Yeah,
I came that experience.
Well, I had a general idea about what the TLU Skills Boot Camp was about, but only a general idea. And of course, early on, I said I met Dan, and Dan insisted on this, and have these Zoom meetings and give me this material to read and memorize, that kind of stuff. And so I went through the whole program, and I thought it was really good because it's about connecting with jurors. That's really what, Dan might say it's about more than that, but to me, it was about being able to connect with jurors. Is there any way I can improve my connection with jurors? And because I was aware that, well, I thought my words were always good, I wasn't sure that I was always connecting with jurors as well as I should. And then I would see some people that I didn't think were nearly as good as I was, but seemed to have this ability to connect with people. How were they doing that? And that's what I wanted to discover, and I thought the TLU Boot Camp could teach me about, and they did.
And so what kinds of things or skills did you acquire or start to at least become aware of in practice from, coming, because this is the place right here. Did it look like this when you came, or was it the older version of it?
It was the older, sleazier version.
the yellows, the greens, the browns.
Yeah. Nothing matched, non-matching chairs, that kind of thing.
Hey, it was part of the process, It was a historical moment, people and memories. But the skills. Yeah. So the skills, reinforcing
that eye contact does not have to be extended. You can have micro glances, short bursts of actually looking at people, and you should look at people for short bursts, not to the point that they become uncomfortable, because they can become uncomfortable. And then you should use your hands, gestures purposefully, not just sort of this egg beater thing. Because lots of lawyers, their gestures are just, that's what they learned from their mother and father, and they'll do stuff that's got unconnected to the juror they're talking to, unconnected to the content that they're trying to deliver. And so that in addition to sort of making this contact visually with people, It's also, can you use gesture to connect to individual jurors one at a time or all of the jurors at once? And how can you do that with physical expressions that bring them into the conversation in a way that just flailing your arms around doesn't? And the obvious, for example, I saw a lawyer in a trial last week point at jurors in closing argument. And I had learned years ago, that's a hostile gesture to point to somebody, to point to a juror, because who likes to be pointed at? Nobody does. But this lawyer had never learned. He was a younger lawyer. If he'd gone to the boot camp, he would have got spanked immediately and says, you can gesture, but you cannot point at somebody because it's a hostile gesture, and they're going to turn off whatever you have to say at that point. So how can you use gesture in a productive way? And it's great. What do you do with your hands? And then what do you have in exhibits? How do you use the exhibits? Do you just put them up and start talking over them? If you use gesture, how do you gesture? What do you look at when you put up an exhibit? So all of those things are part of the teaching and training. And then there was lots of repetition. So you had to try it over and over and over again. And of course, if you got it wrong and you used the wrong hand, gesture wasn't right, Dan would say
That'd be coaching. That's how you get better. And how do you think the videotaping and seeing yourself on video helped you to get better faster?
It was very discouraging seeing myself on video. I'd like to say that, but it was also obvious what the problem was too. You could tell me or anybody what the problem is, and once they see it on video, it's like the problem. They understand what the problem is immediately, and so there's
you try to explain it. It kind of goes right through them, but then you show them like, okay, I get it now.
Yeah.
And after you did the boot camp the first time, you took some time and you did some research and wrote a paper on some of the stuff,
Right. So, the problem with any trial skill, there's always some lawyer who's been very successful, and they just, it says you. This is the way I do it. This works every time, and blah, 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 all that kind of stuff. And the difference between what Dan teaches at the TLU boot camp and that kind of stuff is there's just a host of literature that talks about eye contact, for example, and the use of gesture, and whether it's persuasive or not. And so there's this overwhelming body of social science evidence about gesture and eye contact and tone and the rest of that is the basis for everything that's done at the boot camp. And so it's not just an opinion of somebody. It's just like, wait a minute, there's a social science basis for this, but research has been tested over and over and over again. If you don't do it, you are just abandoning one of the major tools you have in your tool belt.
If anybody, I appreciate you taking the time to write that paper, because people always ask me, well, why? What's your basis of doing this? Why does this work? And I'm like, I don't really have a basis. I just been doing it over and over and over for years, and working with lawyers and just trying to improve it from experience. You did the class. You came back and did the class a second time after you did it the first time. After like a year later. And so, tell us, how do you think the experience doing it a second time was different than the first time? And what was the benefit?
Well, better the second time, certainly. But I'm not sure that Dan would say my performance was better the second time. But it felt better the second time. And of course, part of the problem is these are set pieces where you have to memorize something. And so you have to memorize, and so that once it's memorized, then you're able to just focus on eye contact, gesture, and the rest of it. But if you're having to think of the words, it's going to throw you off sort of the game. And so the biggest problem for me was it's been since a while since I looked at that. My memorization was like, and so you would, even though you would know what to do in terms of eye contact or gesture or movement, you might fail because you're flailing around for what the word is. And of course, this happens in trial all the time. You've got to know what you're going to say before you stand up. If you don't know what you're going to say, then you may fall back and flail around with a lot of stuff that doesn't make a difference. It interferes with your contact with the jurors. So it's like, if it's all about contact with the jurors, we don't want anything to interfere with that. And that would include flailing around for what you're supposed to say or what you meant to say or what your quote was.
Because really, you're right. As I'm trying to teach is connection, because I got a chance to study the greatest trial lawyers in the country all through the pandemic and say, well, how do they do this? Because I'm trying to figure out how to do this too. Because, right, I want to be the great trial lawyer. I want the 7-figure, 8-figure, 9-figure verdicts, but we have to figure out how do these people do this, and it's not easy because there's no set way. There's no bullet point cookie cutter way to become a great trial lawyer, But I know that, obviously you got to have great strategy. You need a good case. But when you have that, it's the delivery, it's the connection with the jury that makes a big difference.
And Dan, rehearsal. I mean, great
Practice.
trial lawyers rehearse, for example, the voir dire and opening statement and cross exams and closing arguments over and over and over again, as opposed to the night before trial. What am I going to say in opening? Or 2 days before trial. And so just like the mastering the physical skills associated with connection, just what you're going to say and how you're going to say it is something you have to practice as well.
And just as far as, talking more about the eye contact, like the way I look at eye contact is that you have to be able to train yourself to micro connect or just look in people's eyes just for a moment. So from a timing perspective, you could really make this micro connections with 14 people in less than 3 seconds. And also to train ourselves to make eye contact with somebody before we start talking. And then we're done, pause and kind of disconnect and make eye contact with the next person. Because that way it makes people feel more special and chosen. And it also helps, it's another tool to help us slow down our pattern of speech so the jury can absorb more. So that's really, I just want to add that into eye contact because you talked about it a little bit.
Right.
Phillip,
Dan, that was, I should have said that earlier. The whole idea of slowing down and taking time was a great learning point that I got from the boot camp. I think other people do because everybody wants to rush. And even when we slow ourselves down, we're still going at light speed for some jurors. And so learning it's important to slow down and deliberately, continually trying to slow down your speech and your connection and moving from one point to another is invaluable.
Right. And also being intentional with everything you're doing, like from the movement of your hands, but also your emotional state, your facial expressions, because, when you stand up there and you're like, good morning, everybody, because you're nervous and you have this stern look on your face, it's not congruent with being a good morning. With it being a good morning, there's a warmth. Somebody says good morning to you, they have a face that has warmth on it, right? Not good morning, because you'll be like, what the hell's your problem, right? When people talk like that. So that's just another thing too, is just training the face so that way you're always intentional and you're always aware. And people are like, this is like acting class. I'm like, yes, it is a lot like acting class because trial is a performance. And if you don't think it's a performance, I'm not sure. That's why you have to rehearse. That's why you have to practice. And what I'm going to ask you a little bit, in just a little bit, is about Sach's trial and the preparation that you did with Sach and the rehearsals you did with Sach and the aspects of trial to get ready to, deliver that $140 million verdict. But, I do want to share something with you. Because since you've been here, we developed a new cross-examination of the, instead of the police officer cross that we used to do to teach the skills, it's the cross of the defense medical expert. And so I think that this is one of my, I developed this with Craig Peters. He's a great lawyer out of Northern California, but I think that the defense of the cross medical expert from a substantive, I think substantively it's very good, but form-wise, to teach form, the skills of cross, I think it's honestly invaluable because I read a lot of cross-examinations and I'm, often like, wow, this is, they get great, even somebody got a great result doesn't mean it was a great cross. You could get great, you could fail at parts of the trial and still win. But so Phillip, what I was gonna do? I was gonna have you be Dr. Phil, famous Dr. Phil.
Oh, you don't want me to be a witness. No.
I'm gonna practice I'm gonna show you the new cross. It's just
all right. Minutes. All right.
See, this is the typical witness. Very arrogant, thinks he knows more than everybody else. The typical Dr. Phil. You ready? Yeah. So just so you know, the skills that I'm gonna be, re-demonstrating to you on cross are the basics of leading questions, only one new fact per question. Those are obvious. But looping, dropping the taglines like right, correct, isn't it true? Dropping all the filler words like and, so, etc. Being mindful of the emotional state, like when I'm asking a question, foundational stuff is inquisitive. Use of the hand in asking the questions. Mindfulness of the pacing of our voice, especially pausing before and after concepts we want the jury to remember. Effective use of a flip chart. I'm not going to do that here because I'm just going to pretend to have a flip chart. Glance control, getting the jury to look where you want them to look. So those are pretty much, and bringing the jury in, getting the witness to adopt phraseology that we inject to it. So again, these are some of the skills I want you to pay attention to, okay, Phillip?
You're not going to get mad at me?
Dr. Phil. Dr. Phil. But Dr. Phil, so you just want to basically say yes and not be a overly difficult witness. I love how you like to do that. So you think it's funny. This is Phil, always messing around. Are you okay, ready? So, Doctor, you're board certified.
Yes, sir.
To become board certified requires advanced education.
It does.
This education, it takes place in medical school.
Surely.
In medical school, you take classes.
Yes.
One of these classes that you take is on how to conduct a proper medical evaluation.
Yes.
So just as right there, that's what I call a connected loop. Each sentence ends where the next one begins, or begins where the last one ends. And so it's very easy to teach people the concept and for them to follow. So back into Dr. Phil. Doctor, you're trained that a proper medical evaluation must be impartial.
I agree.
So now I have a flip chart where it says proper, and I put number 1, impartial, and then I put it number 2, creating curiosity, what's coming next. Doctor, by impartial, what we mean is that you're not an advocate for either side.
That's right.
Doctor, you're trained that a proper medical evaluation must not only be impartial, but it must also be objective.
I agree.
Now I write down objective and put number 3. Doctor, by objective, what we mean is that you don't cherry pick the evidence to support a desired opinion.
No, that's correct.
Doctor, you're trained and you know that a proper medical evaluation must not only be impartial and objective, but it must also be complete.
To the extent as possible, that's true.
So then I write down complete, and now we're going to define it. Doctor, by complete, what we mean is that you consider all relevant information.
Yes, sir. All that's available, of course.
All right. So now, obviously, we're defining what a proper medical evaluation is, and it should be noted that this same cross-examination can be used on any expert. You just got to change how you define these terms. But I'm defining these terms in the context of an expert witness and the trial lawyer. So then from there it goes, Doctor, you're trained and you know that the opposite of a proper medical evaluation, one that's impartial, objective, and complete, well, that would be a biased evaluation.
Yes, sir. Yes, I suppose you could call it that.
Okay, and so again, this is a technique, looping. I've been looping the whole time. So once you establish a fact, then you repeat it in the next statement so that further teaches the witness and teaches the jury. I mean, obviously the jury is what we care about. Doctor, by a biased evaluation, what we're talking about is that's the type of evaluation where a paid expert chooses to only consider information that supports a desired opinion and simply ignores everything else.
Could be.
Doctor, you're trained that there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation.
I'm not sure. I mean, I would imagine that there are. I'm not sure I was actually trained on that, though.
Well, doctor, you're trained and you know that if a paid expert chooses to conduct a biased medical evaluation, that one of the risks is that the jury could be misled about the patient's condition.
It's possible.
So then I have the flip chart, biased, misled, number 1, condition, then I put it number 2, calling now it's the patient's condition. Doctor, you're trained and you know that if a paid expert chooses to conduct a biased medical evaluation, not only could the jury be misled about the patient's condition, but the jury could also be misled as to the extent of the patient's injuries.
Yes, it's possible.
So then I write down injuries and then number 3. Doctor, you're trained and you know, and that's a stepping move. You're trained and you know. So now it's like, this is part of who you are, right? So then when you go against this, it's because you chose to. You did it deliberately, not because you did it accidentally. Doctor, you trained and you know that if a paid expert chooses to conduct a biased medical evaluation, Not only could our jury be misled as to the patient's condition, the extent of the patient's injuries, but perhaps worst of all, to undervalue the human harms and suffering that were caused.
Well, I suppose so.
So again, you got the three in the row, and you got compared the right way that the doctor knows to the wrong way. And this really draws a line in the sand, because how many experts have you ever come across, no matter the field, that did act as an advocate, considered all the information, and didn't cherry pick the evidence? I'd guess like 1 out of 100. You rarely come across the expert, because where they actually don't involve those three, they usually get struck by the defense, because they're not going to call them because it's not what the opinion they thought they were buying, right? So the last part of this is the conclusion. Doctor, let me ask you this question. On December 14th, 2022, you had a choice to make. So just tell us all, what did you choose to do?
I chose to do a proper medical evaluation.
So doctor, so when I say doctor, let me ask you this question. And I pause. That's called a refocusing move. It's like squirrel. So whenever you get to the goal point in a cross, I think it's really good to, hey, let me ask you this question, or can I ask you this? Something that is a refocusing move. And so you said you did so doctor, you want this jury to believe that in fact, that on this date, you did a proper medical evaluation, one that was, and I flipped the chart back over, impartial, objective, and complete, like you were trained to do, and that you didn't choose to violate your training and conduct a biased medical evaluation, and I flip it back over to the bias, because you knew of all these risks. Is that what you're telling this jury?
Yes.
So doctor, I'd like you to come off the stand now, put your signature on this page right here in the date so that we know it's yours, okay? Okay, just remember you're under oath though. So, but like see that cross-examination, it teaches all the skills. And if you think about the pacing of your voice, if you don't pace properly and you speak too rapidly, it's garble. Like if I say, doctor, you're trained there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation. Now it's gonna read the same on the transcript, but the jury's gonna be like, what the hell was that? Because you have to train. If you don't train, you go fast. It's just the human nature of nerves. So, Phillip, that is my modern version of the cross-examination. Phillip used to be he's always very critical of me. That's why I'm always open to criticism, because I know it's for personal growth. It's not because he's mean to me. Although you are kind of mean to me at times, but anyways. So, Phillip, what do you think about the improved cross? You're speechless?
No, I think it'll work with some witnesses.
All right. Thanks, Phillip. See that? Always encouragement from my mentor, Phillip.
Right. Well, the answer is yes. The answer is I think you could use it with any expert. But you've got to be prepared to go beyond that, because you know how experts
absolutely. Are. That's one set of questions to lay a foundation. Because what it does, it draws a line in the sand. Because you wouldn't be doing that if you didn't have the goods. And so it causes the jury to lean in, because, Roger Dodd says, the dog ain't interested in the fish that don't flop. And so you got to cause, and Brian Panish says, I said, Panish, what are you best at? What aspect of trial are you best at? This is when I first met him. I never even met him in person at this point, just through Zoom. And he's like, cross, I know how to find the friction. Oh, no, he says all of them. And so I'm like, okay, if you have to pick one of them, which he's like, cross, I know how to find the friction. And so this chapter of cross, it causes friction, because the witness ain't stupid. They know you're getting, set up, because you wouldn't be doing this cross if you didn't have the goods. But I think it's so critical to set the witness up before you crush them. Otherwise, they can default to, I'm so busy. I'm not really a liar or dishonest. I'm just not perfect. I'm human. The bullshit that they do. I'm so busy treating patients that I just, I didn't have a chance to read it all. Whatever the bullshit excuses that they come up with. So I just want to share my new evolution on cross, Phillip, because it might take some time to absorb, to see, I think it's pretty good stuff, and because it teaches the skills. You got to have the skills, so that you get the skills, you can do any type of, any cross, any cross. And that cross is a really good setup, because let's say it's a biomech. So the only difference is the first part's the same, But the second part, what are the risks of a biased, biomechanical assessment, right? The jury's gonna be misled about the extent of the injuries, about the impact, about the harm and the cause of the harm. And, and that's what these biomech experts for the defense, that's what they're trying to do. They're trying to mislead people. But, as you call them out, I think it makes it tougher. But, and the people Shemek has used it in trial, and some folks have, but really stoked about the result, the effect of it, because it's just a pinning move.
If they just did that on some experts, it would be better than 90% of the crosses that are done, probably.
Right. But again, this is just one chunk, Philip. This is part of a elaborate.
Saying, if they just did that one chunk.
Right, they'd be ahead. But then you just start to improve your skills, though, and you got to practice. I was talking to Rahul Ravapudi when I did his podcast. He practices every cross before he gets to that courtroom. He has one of his associates, one of his one of his trial lawyers, playing the witness, practicing the cross, practicing the use of visuals, practicing the rhythm, practicing when you want to bring the jury in. People have just got to practice, because they're going to be so much better and confident and calmer if they practice. So Philip, I know that the one thing that we didn't talk about as far as what you're teaching in Vegas is the first hour on Saturday afternoon is with your good friend, and all of us are a good friend and great, Sach Oliver. So tell us about that. We talked about that trial a little bit, and I know the first hour is going to be about that trial. All right, so that's really what I want to talk to you about, that trial, and what you did to help Sach get to where he got. So you said that. So it was a trial. It was a Kroger truck driver smashed into another semi that was disabled or had flipped on the road, and ended up hurting that the driver that was, that had flipped, but also killing a young man that had pulled over to render aid, who was in some capacity a fireman in the communities. Did I get all that? Great for a quick little summary of it.
Close enough. It was a wrongful death case. The defendant, Kroger, never accepted responsibility at all. They claimed it was an unavoidable accident. They blamed the initial wreck on a trucking company. The driver, it was a single vehicle accident. He turned his truck over so it was on its side, and all you could see as you approached the scene, blocking one lane, was the undercarriage of the trailer. So there's no reflectors, there's no lights, no anything. And so they hired an expert to come in for $75,000 and say it was an unavoidable accident. There's no way he could have avoided this impact. And then they blamed the young man who was killed by saying, well, you were a firefighter, and by the way, he was killed at the scene. So all they knew, he was the firefighter. He got out of his car, and so he was on the job. He's on the job. He shouldn't be able to recover against Kroger, because fireman's rule. That's what it's called in Arkansas, at least. And they're saying he was on a job. And of course, the family who lost their son, they had two sons, and this was the youngest son, and just, a dear, just a fine young man. It was a tremendous loss to them, but after the death, they wanted him to be recognized in some way by the local fire department. And so there was early correspondence about, well, this is in the course and scope of his duties. He was in the course and scope of his duties as a fireman. He was doing the right thing, and we would expect him to stop, and all that kind of stuff. And sort of unwittingly playing in the defense's case, which is, well, he was on the job as a fireman, and therefore it doesn't. It's the fireman's rule, and you can't sue Kroger for whatever the Kroger driver did. So that was a complicated legal issue in the case. But the other issues was it unavoidable? And so what we really did early on in the case is we explored all the defenses in the case, including, was he on the job? Are they going to be able to use that as a defense to prevail and keep Kroger from paying anything or accepting any responsibility for the wreck? And the second thing was it really unavoidable? And of course, it's 5 o'clock in the morning, it's dark, there's no lighting on the undercarriage of that vehicle, there's pictures taken at the scene. It's like, oh my God, you can't see anything. So is that unavoidable wreck? Is that a defense? How are we going to deal with that? And so those are the two biggest things that we had to deal with. And early on, the legal defense, which was he's working as a fireman here, so therefore there's no liability on Kroger. And so early on, that was the first thing, legal issue, one of the trial team had to take on, and they got a motion for partial summary judgment, sort of taking that out. So that's good. But the other thing, in terms of building the landmines in the case and the things that keep us from making any recovery, was that the fact it was an unavoidable wreck on the part of the Kroger driver. And as part of the discovery, says we've got to establish that there were other vehicles in the same position as the Kroger driver that were able to go by and avoid contact. And so part of the discovery became, how do we prove the fact that what this Kroger driver did was not the norm, that everybody else was able to see it and go by it, or at least some people were able to see it and go by it. And so that ended up being a critical part of the proof. And when we came to trial, the proof evidence ended up being, because we wanted to have a representation, a physical representation of what the facts are in the case, that Sach and Jeff Hamby, who was his partner in the case, they got 17 scale tractor trailers, white plastic tractor trailers, and another 6 or 7 passenger vehicles, because they were able to establish that's how many tractor trailers and how many passenger vehicles had passed by this scene and didn't strike the trailer, didn't wreck, didn't cause a problem. And then when the tractor trailer driver for Kroger was deposed, they said, "Why did you hit this?" He said, "I didn't see it." Well, all these other vehicles see it. Why did you see it? So they got, as part of the discovery, all of the eye testing for this individual. And what they discovered was this man had multiple eye tests where his vision made him ineligible to drive a tractor trailer. He never should have been behind the wheel, and Kroger knew it. But he was successfully able to pick up his loads and deliver his loads, and he had some small sort of collisions while parking, when he's delivering a load of groceries to a produce to a Kroger store. But they wrote those off as just, well, that's just the kind of thing that happens. It's a tight space. It's hard to get around. And so nobody ever did anything about his vision. Nobody questioned about his vision. He was never taken off work because of his vision. He was never offered another job that he could do where his vision wouldn't be important. But if you know anything about vision, the minimum for a truck driver is 20/40 in both eyes. And there were points in his career when he's driving with his vision was 2200, which is like, there's no way this man should be on the road driving a tractor trailer. But it was okay because he was able to routinely make those deliveries. And so the vision ended up being the huge part of the case because the man shouldn't have been on the road. And then Kroger constantly accepting no responsibility and blaming, the young man who was killed, blaming the truck driver who had lost control of his vehicle and turned over on its side, and taking no responsibility for their own driver and saying he was perfect was too much.
Can you tell us what was the highest offer in the case? Do you recall?
I think I can. Pre-trial, I think they had offered. Pre-trial, I think they had offered 6 or 7 million pre-trial. And now there were, of course, during a trial, offers go up. But Sach had someone who was negotiating on his behalf, because when you're getting ready for trial, you really don't want to have the distraction of having to negotiate back and forth, listening to all these counters. And so he hired somebody who's a former professional insurance executive who had dealt with large number of cases, and he had full authority to settle the case and dealt with all those interval and negotiations. But the bottom line is, they made an offer that could have settled on the case. They reneged on the offer, and then all their offers after that were less than that. And so there's no choice that the case had to go to trial.
And how much was that offer that they had made that they had withdrawn?
$20 million.
Or,
and they reneged on it. Yeah. And then after that, there were these incremental offers during the trial. But once the trial was started, Sach had the confidence and really the courage just to go forward. And he had talked to. Now here's one thing that Sach does that other people don't do. Sach is very humble. He's the most humble lawyer in the courtroom all the time. He's also the most polite lawyer in the courtroom. But when I say he's humble, he would call every night. He would be on his phone to people he knew, friends of his, people who would give him good advice about, what do you think I should do? He didn't pretend that he had all the answers to any questions at any point in time. And then every night I would get with him because I would be talking about, we would have a shadow juror running during the trial, and we talk about what was the response of the shadow juror to the evidence today. What did they like? What they didn't like? What do they think was the most important point made? What do they think was the most memorable exhibit? What do they think about the defense lawyer? What did the defense lawyer do that really made a difference to them? All those kinds of things that you would want to know, so that throughout the trial, he was not just getting the direct feedback of looking at jurors and looking at witnesses and watching the proof go in, but he was hearing the kinds of responses the potential jurors might be making to the things he was doing, hearing, and saying.
Phil, I know you and Sach ran multiple focus groups on this case, because I know, because a lot of times I was talking to you over the last several months, you're on your way to Rogers, Arkansas, or somewhere like that, or another focus group with Sach. So give us some insight on these focus groups that you and Sach ran, and and what the benefit was to this final product of this fantastic verdict.
So the process I usually use is we'll start off with what I would call a landmine session. That's a term, by the way, that I got from Rodney. But a landmine session is, let's figure out everything that if a juror or the judge believes is true, is going to cause us to lose the case or significantly affect our damages. So that's a landmine session. So we're basically coming up with a model of the defense case. All the things they could potentially prove or say that are going to affect the outcome of our case in terms of liability, causation, or damages. So we spend a day, sometimes 2 days, just putting together that document, which is written. And that's where we say, okay, this is a legal defense. If we don't pay attention to this particular legal defense right here, we are done. And if we don't put on evidence as to this particular issue, this is the most important evidence in the case, we are done. And so in that case, the legal defense of the so-called fireman's rule, we knew if we didn't take that out, we were in big trouble. And we knew it months in advance. And the whole thing about, was it an unavoidable accident? We could foresee that as a defense. And we knew also that it's dark. The undercarriage of this tractor trailer doesn't have any lights or reflectors. That could be a defense that sells. And so once we identify those things, the next thing to do is we typically will then test it. And the first test that we do is typically by survey. So we'll survey maybe 100 people about the issues in the case, the things that they feel strongly about, or strongly against, the things that they didn't see, things that they want to know. And so from that, we say, okay, is there anything we're learning from this that we didn't get in our landmine session? Any problem or any perspective? We'll ask them for metaphors. Is there any metaphor that they can give us that we can use? And so before we get into the heavy discovery, we've already worked through what we think the problems are in the case are in detail. So we'll have 30 pages of outline of here's the stuff that we have to be worried about. Here's the facts that we have to be worried about. And then here's how we're going to, in a rebuttal, how we're going to counter those things, make those things irrelevant or immaterial. Then let's survey it, see if it works, see what doesn't work. After we've done a survey, now we have a pretty good sense of 100 people. That's a lot of focus groups. Now we'll go to a live group and see if we're getting anything different. If they're talking about it differently, and we have a good idea at that point of what our most persuasive evidence is and what the problems are in the case are. And sometimes we'll ask them to help us. What would make you feel differently about this particular issue? What would be persuasive to you in terms of changing your mind about this? So that's the kind of open-ended, qualitative question you can ask in a live focus group. So we would do that. And then after we do that, we might do another survey, right? Because we may acquire new information that we didn't have in the first survey. Maybe that first survey is not entirely what we want to say about the case. So we may do another survey. Surveys are quick and relatively inexpensive, and we can do a lot of people. So I'm a big fan of doing surveys. Then we're going to do live groups before trial, which typically are going to focus on voir dire and opening statement. Because from my perspective, voir dire and opening statement, if you've got a good case, those are the first two things you do. You've got to do a great job at both of them. If you do, you're going to win the case. So we would rehearse. The voir dire for Sach is we would work through a PowerPoint on voir dire, a PowerPoint on opening statement. We would go through 4 or 5 iterations of both of those until both Sach and I were happy with it, and Sach was comfortable with being able to deliver it. He would then practice it on his own. Before he ever got in front of live people, he would practice it repeatedly, both the voir dire and the opening statement. And then we would bring in a live group of 20, 25 people, 2 groups, maybe one in the morning, one in the afternoon, and he would do voir dire, which would be, he's already practiced, we have a set PowerPoint for it, and opening statement. And then we debrief them afterwards to see what's working, what's not working, what else they want to know, what they like, what they don't like, what was the most effective visual for them, what was the thing that helped them drive their decision-making in the case. And we know all of that before we go into the courtroom.
So you ran, if I counted correctly, you said you ran 5 different focus groups on the voir dire in the opening until you were happy, and then Sach continued to practice on his own.
Yeah.
And you also ran and conducted a shadow jury for this trial. And you're the only consultant that I'm aware of, and this is the only trial that I'm aware of that, in all the trials I've broken down on the case analysis over the pandemic and over the years, where a shadow jury was present, except maybe the other Sach case that you did with the rollover tank with the fumes.
Oh, we did a shadow jury on that. I guess I've done a shadow jury on 3 or 4 cases with this point with Sach.
Right.
And it's when you're in trial, I mean, you are so involved as a trial lawyer, worrying about the order of proof and your witnesses and what are you going to do next, that thinking about what people thought or felt about that day's worth of proof, hey, you don't know. And you really don't have time to think about it either because you're worrying about the next day. So what did people really think about that witness? What's really working for them? What's not working for them? What do they think about you? What do they think about the other lawyer? You don't have time to think about that. And if you ask anybody, they don't know. And so what a shadow juror does is give you this, these are independent third parties. They're not involved in the case. They're not jurors, but they could be jurors. And so did they like a witness? Did they understand what did they think? If they heard a whole day's worth of testimony, what did you learn today in the case? If they say, for example, I did that in Sach's case, and the defense put down a whole day, basically, of witnesses, which sitting there as a lawyer, I thought was pretty useless. But it doesn't make any difference what I think. The shadow jury go back and said, so what did you learn today? And I went over who the witnesses were. We heard this witness on, they talked about this, blah, blah, blah. I went through 5 witnesses. So tell me now, based on that, what did you learn today? I had 8 people. The uniform consistent answer was nothing. They didn't learn anything. Okay, so are they just like the jury? And the answer is, no, they're not just like the jury, but 8 out of 8 people said they didn't learn anything. So I'm thinking this was not an effective day of testimony for the defendant in the case. Now, when I take that back to the trial team, it's like, are they going to rely on that information? No, but I'm much happier hearing that because I was worried about some of that information. I was worried because I'm in the weeds. Everything's important. I'm a trial lawyer. I am in the weeds. I'm worried about everything. And then these people who could be jurors sit there, I didn't learn anything today. It was a waste of time. That's good news if you're a trial lawyer. So that would be an example. But there are other examples where, as the lawyer, you just don't know. For example, we had punitive damages against both the driver and the company in the case. So Sach's inclination and some of the people on the team was, let's let the driver out of the punitive damages claim. He's living in a townhouse. He's got 4 kids. He's just a driver, right? And I tended to agree with him. We'll let him out of the punitives claim. Maybe that'll earn us some pluses with the jury. So I go back and talk to the shadow jury and explain what the process is. How would you feel about it? 7 out of 8 said leave him in. So I'm kind of going, oh, okay, let's leave him in. And did Sach have to follow that advice? No, but it was pretty good information. It's like 7 out of 8 say leave him in. It's like, well, are we going to hurt ourselves by leaving the guy in? I don't think so. I mean, if it was 50-50, that would be different. But, there wasn't any question. They thought leave the guy in on that punitive damages count. Now, Sach decided to not pursue the punitive damages, even though the jury said yes on the verdict form as to punitive damages, because we wanted a clean record. And if we get into punitive damages, they're going to give us a verdict. It's just going to be an appellate issue. We've already got a shot at getting a really decent verdict. We don't want to screw it up by going after the punitives. And so, of course, we had a $140 million verdict. We don't really need the punitives. And we also know that as a practical matter, those jurors, in talking about the compensatory damages, were thinking about the bad conduct and roll that into their evaluation.
Phillip, we're going to be seeing each other real soon. in less than 2 weeks at Caesar's Palace in Las Vegas. And, because you've been to, I remember when you came to the first TLU, I don't remember actually seeing you there, but I remember somebody telling me you were there because they're like, Phillip Miller's here, the Middle of the Mousetrap guy. I didn't know who you were, but apparently in their world, you were famous. So I thought that was really fantastic because a lot of times when people have quite a bit of success, they no longer attend conferences as a student. I know some people are like, I'm not coming to a conference unless I'm speaking. I'm like, ooh, aren't you so fancy? I guess I just like to, I like to be around the trial lawyers. I like to, see what they're doing, absorb, spend time with them. And so how would, tell me, like, you've been, you like you said, you've been with AAJ for, teaching AAJ. You're involved in a lot of programs, all this stuff. So tell us, how is Trial Lawyers University, from your experience, how is it different than other programs and other events you've been to?
Well, there's a wide range of topics having to do with trial. No matter what your specialty area is, you're going to hear someone speaking on that as in the substantive areas associated with trucking or nursing home or medical malpractice or civil rights or employment discrimination or whatever it might be. There'll be substantive content on that. And then in addition to that, there's going to be lots of people who are not only just be talking about content, but actually talking about taking that content and trial presentation and what they did that made them very successful in an individual case or maybe a career full of cases in the case of some of the presenters. So really quality presenters, very focused presentations on subject matter areas that may be of peculiar interest to one participant or another. And then to the generalist, just in terms of voir dire and framing cases and all the things that go into effective depositions, effective cross-examination. So all of those sort of generalist areas, if you want to learn and get better. So you see people who are really, really good at it and have had good results, as well as the people who have specific results in an area that you're interested because you happen to have an employment discrimination case or a trucking case or a nursing home case or a medical malpractice case. So it's got that wide range of content with quality speakers, and it's fun. So there's lots of opportunities for network. Dan is a big believer, for example, you can go to these programs where you're really drinking water from a fire hose. I mean, it's just too much information over too long a period of time. People get burned out. And so Dan is like, ends each program on time so that everybody can take a break. They can get themselves refreshed and go back for another dose. But it's not like we're going to do 8 hours of pounding information into your head. Dan won't allow that in his format. And I've had the experience the first time I think I taught, I'm in the middle of a program arbitrarily stopped at some time period. And I wasn't done.
Hold on a second, Phillip. Nothing's arbitrary, okay? Everything's scheduled. And it's try to do it because there's so many different things going on, but people need breaks. And, so many lawyers are like, who wants to take a break? And of course, nobody's going to tell anybody to sit down and shut up. We need a break. But inside they're thinking, please take a break. I got to go to the bathroom. I got to make a phone call. I got to get something to drink. But so it's not arbitrary. I want to make clear on that.
I'm on a roll and I'm having a great time with these participants. We're making great progress, but the time is up. And Dan comes and stands in the back of the room. I'm going, why is Dan standing in the back of the room? I say, hey, Dan. He gives me the stop, anyway. So the bottom line is, so I learned after that lesson, is like, there's a limited amount of time, stop when the time's over. And the fact is, even if you think, first of all, people always ask me, how did you do? And my answer is, I think I did great. Did I not do great? But that's not necessarily the perspective of the participants. So the program is designed for participants, not for instructors or teachers or the lawyers who are presenting. It's for the participants in terms of making the instructors and the teacher break so they can come back, or they can go to another program, or they can deal with something at the office. And then you don't have to leave the site to eat. There'll be breakfast there in the morning. There'll be lunch. There's social events at the end of the evening, so you have opportunity to get back together with people you met during the day. And so it has all those different components. Great learning from great educated and well-skilled attorneys, as well as an opportunity to network and have a cocktail, have some fun. I think Dan usually has a costume party.
Halloween. It's an annual Halloween party.
Can I tell you my Halloween joke?
Oh, tell us.
Do you know why witches can't have babies?
No.
Because goblins have Halloweenies.
Okay. Thank you, Philip. That's a good dad joke.
It's the only one I know. It's the only one I know. But
Fair
so
enough.
Halloween, I think the first one I went to, I went as a baby shark, and I got a costume for $39 from Amazon. I put it with a shark costume, and it had the little baby shark tune and could play it whenever. So
Right.
it was designed so I could still put my hands through the fans and hold a drink. So it was an okay costume.
Perfect. Well, if anybody, let me tell folks, we got almost 1,100 people registered right now. Probably be about 1,200 by the time we get to October 16th. We got 9 lecture tracks with some of the top trial lawyers and trial consultants in the country. There's one track that's just the trial consultants track with, the likes of Eric Oliver, David Ball, Sari De Lamotte, Jesse Wilson, Harry Plotkin, Jessica Brylo, etc. But we have 8 other tracks besides that, like Joe Fried and Sach Oliver are teaching for 3 full days. And I'm going to ask you in a moment about what you and Sach are teaching on Saturday afternoon. Sean Claggett and Sykes Trial College, 3 days of how they do it at Claggett and Sykes. They are, one of the, Sean's hit 8 verdicts in a row that have 8 digits in them in the last couple of years. Brian Panish, Shea and Rabapudi. That firm is a machine. They got over 50 lawyers, they got 8 lawyers that have 8-figure verdicts, and they do all kinds of cases. They're going to be teaching for 3 days on how they work these cases, how they put them together at PSR with Brian Panish and Rahul Ravapudi and Adam Shea. And then Nick Rowley and the Trial by Human crew. That includes Jacob Norman, Dan Shar, Henry Pecor, etc. Courtney Rowley. They're going to be teaching for 3 days. And how they've done it. And, Nick and I go way back to the Trial Lawyers College. We were roommates back there. And, I knew him at the beginning. And it's been so great to see his evolution and his progress and his skill development. And it's been inspirational because I didn't take that same route. I went a little bit different route. But now I have a way to get to there, a model of how to get there, what I have to do, the things that we have to learn. And so we have some of the greatest, and those are just the lecture tracks. There's going to still be 15 workshop tracks. And Philip's teaching a workshop. There's a workshop every day on the cross-examination that I just demonstrated. Every day on the presentation skills that we teach at the boot camp, the voir dire skills we teach at the boot camp. Michael Cowan's teaching a 1-day big rig masterclass. Ben Rabinowitz, he's a gangster trial out of New York City. He's teaching a 1-day masterclass on expert cross-examination. Michael Hill out of Cleveland, he's teaching a 1-day masterclass on elder abuse. The guy's that's all he does is elder abuse. He's hit more elder abuse verdicts for 7-8 figures than anybody else I know in the country. Getting money for people that got a month left to live. Getting big money, getting 8 figures, that's skill. David D. Robertus, he's teaching a workshop on framing your employment case. He's had 5 verdicts in a row that have 8 digits in them. These people are at the top of the game. Steve Bardazarian, he's teaching multiple workshops on jury selection. And, he's killing it in LA. And so there's all these great trial lawyers you have the opportunity to learn from in these small groups and get to know people, because in all the workshops, people have, have Zoom meetups ahead of time. Daryl Isaacs, he's teaching a class on marketing and running, operations. He's built a really big law firm that's done a few $1 billion. And now he's on his transition to becoming a trial lawyer. There's just all these classes to do, all this stuff to learn. Besides that, like Philip was saying, we do a full breakfast, a full lunch for every day in the exhibit hall. We have great parties for everybody. The opening party is at the Omnia nightclub out on the terrace. Thursday night's party is an 80s party. We got a great band coming. Friday's the Halloween costume party with live band karaoke. People really get into that. And Saturday, Brian Panish is hosting a closing party at Dre's Underground, which is right near Caesar. So we really worked hard to put it together to make it the most awesome event and transformational event that anybody's ever been to, because I really, focus hard on trying to make every event better than the last one. And on top of that, it's great for networking, Philip, because we ask everybody to do a personal bio, sharing a little story of the first person of who they are, in addition to being a trial lawyer. And, it's great because maybe you meet somebody and 6 months later, they remember you and they have a case in your jurisdiction or a case in your specialty area, want to contact you. They can find you now, because they learned something about you, and they can look you up. And so these are the things that trying to put we put into place and try to improve upon every conference. To it's all about the user experience. And I'm pretty stoked about this conference, and I'm really glad that you're coming and so much you're teaching. And I do want to touch upon what you and Sach are teaching for the last 3 hours before we close out here.
Yeah.
What's the final Saturday afternoon? And by the way, whether you're coming to TLU or not, I want everybody to know that everything is being recorded. All these 9 lecture tracks. Oh, there's a jury ball track too, so you can figure out how to use this big data research. But all these tracks are being recorded, and they'll all be available on TLU On Demand. And if you get TLU On Demand, it's a app for your phone, so you can watch anytime, anywhere. We collect all the pleadings, transcripts, and PowerPoints for all these cases. There's over 485 webinars and 3 years of live conferences. That's 3 years of TLU Vegas, TLU New York City, TLU Huntington Beach. All of it's been recorded. It's all there. And I'm really stoked because in about a month, a new version will be released that's been, we're building a tool with AI to transcribe and index all of this content, so it'll be much more searchable. And if you don't currently have TLU On Demand and you want to try it out, shoot me an email, dan@triallawyersuniversity.com, and I will shoot you a trial subscription so you can use it before you buy it, and make sure that you're going to use it and you're going to get value from it, because the people that use it swear by it. It changes their life because there's so much to learn. You got to be a constant student of the game. And so just want to add that last piece there. But Phillip, tell us, Saturday afternoon, Sach Oliver and Phillip Miller, what's that show going to be about?
Well, one piece of it is going to be sort of a case analysis and deconstruction of this $140 million verdict that we got last week. And Sach is going to be there. We'll tell you what we did from the beginning, the jury research, the focus groups, the surveys, the mock trials, the demonstratives, the directs, cross, all the rest of that kind of stuff. And you'll know what Sach's approach is. I can tell you, for example, Sach he knows exactly how long every witness is going to be. He's timed every witness. He's timed his opening. He knows how long things are going to be because he's practiced it. So he's a great example of someone who is disciplined and as well as humble, and has this gift of authenticity that is hard to teach, I think. But so we're going to tell you everything about this case. Answer any question you may have. In the process, we're also going to talk, because the fundamental part of that was one of the ways that we've been using to communicate with jurors and persuade them is timelines. But we're not using timelines in the way I typically have seen them and we typically see them. The timeline is not on a PowerPoint. So typically we're using a physical timeline so that jurors can see the scale of the acts or behaviors that we're talking about in the case. And Sach will build that timeline data point by data point using little dowels with a little point on it or a red flag. And he'll go through the whole process. And whether it's 6 months or 4 years, he'll have 1 2x4. In this last case, we used 2 2x4s that are 8 foot long to capture all the relevant data points in this case. And the opening statement walked through that entire PowerPoint, not through PowerPoint, but that entire timeline. It was on a physical 2x4, 2 of them. When the opening statement was done and the people saw these 2x4s, this tremendous timeline, the case was effectively over. And so we're going to demonstrate that and talk about timelines as well as lifelines and plot lines, which is sort of a different thing for a different aspect of damages. But it's a tremendous tool in most cases because people ask, I know from doing focus groups, when people introduce a lot of dates, there's always this question about, is there a timeline? So why aren't we giving them a timeline of some kind? I mean, there isn't any case that doesn't probably need a timeline, especially if you want to focus on the defendant's conduct, which we usually want to do. There's no better way to focus on the defendant's conduct than have a timeline that has one data point after another about the defendant's conduct.
All right. Phillip, our time here has come to an end. But if people want to get a hold of you for any reason, what's the best way to contact Phillip Miller?
Well, email me. If you just look at philiphmiller.com, that goes right to my website. Or you can email me at pmiller@seriousinjury.com. pmiller@seriousinjury.com. And come to the conference. I've got some special bookmarks that are cut out of me holding a large tray of money. It has all the contact information and a QR code on the back of it. And everybody needs a book. So bookmarks.
Phillip, if anybody was on the fence about coming, I think you just put him over the edge. All right.
The free bookmark.
You just tipped him. The free bookmark. The free bookmark. And
I'm bringing some neurogum with me.
Wow, this is going to be amazing. If anybody needs to get a hold of me for any reason, whether it's for TLU On Demand, boot camps, or talk about Vegas or Huntington Beach, anything at all that I can help you with, I gave you my email a moment ago, but it's dan@triallawyersuniversity.com. And my cell is 248-808-3130. It's the best way to get a hold of me. So sort of email me, text me, or call me, and I will take care of it for you, whatever it is you need. All right. That's all I got, Phillip. Take care.
Pleasure. Thank you, Dan.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.